has lied to the minor child about blowing up schools and shooting up schools, and I believe that's why he won't talk to me, because
stating his intention to send Metro to the plaintiff's residence, an address that was supposed to have been confidential. He told the officers that his dad calls him when he wants, and he does not want to deal with his dad.
The fact that this doesn't stop, this won't stop until you get what you want, and even when you get the orders you want, it won't stop, because then you'll say they're not complied with. It'll be a vicious cycle. You want to endlessly litigate this. Why don't you do something novel and make him maybe want to talk to you? But if for the last 6 years there's been nonstop gazillion lawsuits and proceedings against her and a bunch of agencies and that level of stress.
What, Judge, why would you make that invitation?
Thank you.
I will absolutely do that, Your Honor. I will supplement that.
Thank you, Your Honor, for ensuring that this interminable proceeding continues. This is absurd, and I object to the court's invitation to Mr. Phillips.
You still interpret it as some malicious intent to encourage someone who's addicted to litigation. And even if someone's declared a vexatious litigant where they cannot file no further motions without court clearance, what difference does that make in a case where, okay, you're not going to hear my case, I'm going to file all these appeals and a million other lawsuits. Okay, we're on the record on the Phillips matter. Happy New Year. It's case D. May we have appearances, please?
Good afternoon, Your Honor. Shannon Wilson, bar number 9933, on behalf of plaintiff, who is also present separately via Blue Jeans.
Excellent. Good afternoon.
Good afternoon, Your Honor. May it please the court, initial T period, Matthew Phillips, California State Bar number 165833. I am not licensed in this state.
Okay. Starting with the petitioner's side, Ms. Wilson, what's there to report, if anything, in terms of status or anything else?
Nothing to report, Your Honor.
Okay. Mr. Phillips, with the understanding the courts received and reviewed your filings of November 3rd, what would you like to inform the court of?
Well, there's a great deal that I'd like to say. I contend that there's been 299 violations of the order dated December 19th of 2020. And in the past 2 months, there's been an additional 16 violations. There are 16 dates that I'm entitled per the court order to phone my son, and yet there's been no contact. Every time I call, the calls go straight to voicemail, and I submitted an additional affidavit last week from myself and affidavits from my father and my brother, because there has been no contact from anybody in the Phillips family. Minor child has a grandfather here who's almost 94 years old. He has uncles and cousins and aunts, and yet there's been no contact of any kind whatsoever. And it's been my experience that in the days leading up to a hearing on OSC, the party who's required to appear on the OSC, they generally make some kind of effort to open the door to rectitude, as it were. But apparently there's been no effort of any kind on the part of, that's the mother. There's been no effort of any kind to comply with the court order. And without, I have a whole presentation, but the brief summary is that I think that some form of sanctions are clearly appropriate here, because she intentionally and willfully violates the court order that entitles me to speak to my son. And in addition to the court order, there are several Supreme Court cases that clearly delineate the right to familial association. That would be United States, I can give you the citations here. It's United States, Roberts versus United States J.C.'s. That's 468 U.S. 609. It's a 1984 case. And Rotary International versus Rotary Club of Duarte, 481 U.S.C. 537. That's a 1987 case. And even if there weren't a court order, there is, but even if there weren't, these two Supreme Court cases stand for the proposition that I have a right to intimate and expressive speech with my son in private, and yet way of that, I believe, is alienated the minor child, and I believe she acts with specific intent to violate my rights. I believe this is a clear-cut case of custodial interference, and I would ask that the court do whatever the court thinks is appropriate to facilitate my contact with my son. I have had no contact in 6 years, and this is just extremely upsetting. And so, without going into further detail, that's my opening salvo, Your Honor.
Okay. Ms. Wilson?
Thank you, Your Honor. The facts of contempt must be presented to the court by an affidavit. That's NRS 22.030 sub 2. That affidavit is jurisdictional, and where the affidavit fails to allege essential material facts, that deficiency cannot be cured by proof at a hearing. Additionally, EDCR 5.509 sub A provides for essentially the same thing. Here, Phillips' declaration, which was attached to his motion filed on November 3rd, did not include a statement of what Ms. is supposed to do. Because, Your Honor, there is no order that directs her to do anything in this regard. The court's order entered in December of 2020 stated that the defendant may call the child on Wednesday and Sunday at 6:30 p.m., and the child may freely call the defendant. This order does not direct Ms. to do anything at all. Therefore, there is nothing to enforce, and there is nothing upon which she can be ordered to show cause. Even if we were to look to Mr. Phillips' separately filed statement, which does cite the provision that allows him to call his son to relieve him of the jurisdictional defect, the Nevada Supreme Court has held an order on which a judgment of contempt is based must be clear and unambiguous, and it must spell out the details of compliance in clear, specific, and unambiguous terms so that the person will readily know exactly what duties or obligations are imposed on her. That is Cunningham versus 8th Judicial District Court, 102, Nev 551. The December 19, 2020 order does not spell out any obligation of Amber. Similarly, as a motion to enforce, there is nothing to enforce against her. Moreover, the child is no longer a minor. Therefore, the court lacks jurisdiction to make any orders concerning child custody. NRS 125A.035 defines a child as a person not attained the age of 18 years, attained the age of 18 in of 2023. Consequently, Mr. Phillips' motion also fails as a motion to enforce. It must be denied and the order to show cause struck. I would like to also point out for the court, if it did not read the opposition and the request for submission of a proposed order,
The court did
Mr.
read all
Phillips,
that. Did read all that. In
okay.
abundance of caution, the court's protecting the
Thank
record
you.
by also affording the right to a hearing. But
Understood. Would you like me to go on with the prior motions that Mr. Phillips filed?
If you believe it further bolsters the record. That's great. Whatever determination either party wishes, they can bolster the record in any fashion they see fit within reason. So proceed.
Thank you.
Thank you.
That on July 28, 2021, as well as November 13, 23, Phillips filed these motions related to phone calls. He also filed April 2, 2019, June 25, 2019, and February 16, 2022, for a total of not less than 5 motions relating to phone calls, none of which granted the relief that Mr. Phillips seeks, then or now. In the findings of fact set forth in December 19, 2020, the court found encouraged the child to contact dad and allowed the child to do what he is comfortable to do regarding contacting dad and his paternal family. Additionally, the court has made the following representations throughout the course of these proceedings. In her opposition filed August 30, 2021, she stated that she is informed and believes that Dan has not communicated with his dad since December of 2018. Since February 2019, there have been orders allowing Mr. Phillips to engage in reunification therapy with his son, which he failed and refused to do. There was also times at which Phillips was ordered to see his son at Donna's house. He declined those opportunities too. The court's final order in December of 2020 again had ordered Mr. Phillips to reunification therapy with his son, which he declined and failed to do. Represented in that same August 30, 2021 opposition that she has continued from time to time to encourage to reach out to his dad but is not interested. He becomes agitated at times when he has pressed the issue of contacting his dad or dad's other family members. She's also continued to check in from time to time to see if he wants to resume his own therapy. He indicated he knows it is available. He did not want to do it.
Objection, Your Honor. I have to make a hearsay objection as to what Ms. Wilson contends the minor.
This is argument. It's not really testimony. Plus, she's referring to findings in the record. She's not presenting something new, a new factual assertion that she's asking the court to make a finding on. She's referring to historical findings and material in the record. So it's permissible. Proceed, please, Ms. Wilson.
Thank you. Opposition filed August 30, 2021. This stated the child's phone number is unchanged. The minor child is in full possession of his phone. She's not unlocked. She's not blocked dad's number, and she has checked his phone and at that time had not blocked dad's number either. She does not know, as we sit here today, whether he has subsequently blocked the phone because she has still never taken possession of his phone. It has been and continues always to be in possession. Importantly, Judge, in the opposition filed August 30, 21, plaintiff recounted visits that she and received from Metro conducting welfare checks August 26, 2021 at 2 a.m., yes, 2 o'clock in the morning, and August 29, 2021 at 10:43 a.m. The officer spoke with the child on both occasions. Stated she's informed and believes that he told the officers that his dad calls him when he wants, and he does not want to deal with his dad. Plaintiff's opposition explained she knew Phillips was the source of the welfare checks because he emailed her counsel, that is me, a few days prior on August 13, 2021, stating his intention to send Metro to the plaintiff's residence, an address that was supposed to have been confidential. The email that Mr. Phillips sent to me, stating his intention to send Metro to the house, was provided with that appendix of exhibits on August 30, 2021, Exhibit 3. Your Honor, I will simply refer the court to our opposition and to the request for submission for the myriad other representations that Ms. has made during the course of these proceedings that she has not now, nor has she ever interfered with the defendant's ability to call his son or with his son's ability to call his dad. Thank you.
Thank you very much. Mr. Phillips?
I would like to be heard here on this. I just find it truly remarkable because what Shannon Wilson is really doing is criticizing Ochoa for an inarticulate order. She's saying that it's vague and ambiguous and she can't figure out what they're supposed to do. The point is that if I'm entitled to make phone calls, I think the court can exercise discretion and fill in the blanks, and it should be obvious that it has a duty to bring the minor child to the phone, because the minor child...
Let me ask you this. Now that he's 18, what do you expect her to realistically do, not just legally, but physically, emotionally, psychologically, etc., if he's saying, no, Mom, I don't want to talk to him? If that's the case, I don't know. Under that scenario, what would you expect her to do with an 18-year-old now young man and not technically a child under the law? How should she make that teenager comply at this point?
It's my contention, well, there's two ways I want to answer that. First of all, yes, he is 18.
Let's just have clarity. Is it a matter of getting her punished for what you feel she didn't do from age to 12 or 18 through 17, in which case I at least know I know thematically that's where that is? Or are you looking to establish something constructive with him and the relationship with him now that he's 18? Which there's no improvement. She isn't able to, the court, no one's able, the court, her, no one, Miss Wilson is able to prevent him from speaking to his dad if he's so inclined. He's 18 now.
Well, but yes, he is 18, Your Honor,
Okay.
but I believe he is still subject to this court's jurisdiction because I'm still subject to...
Why don't you do something novel and make him maybe want to talk to you? But if for the last 6 years there's been nonstop gazillion lawsuits and proceedings against her and a bunch of agencies and all, and that level of stress, and this being considered, that's arguably not going to put him in the psychological frame. I don't doubt what you're saying is true, that there's this resistance. I don't doubt it after everything that's happened the last few years. What can constructively occur now? I'm not talking about what orders could be issued to punish her for what she didn't do when he was 12, 14, 16. What constructively can be done now, even if you were to argue he's within the jurisdiction of the court, which at 18 he apparently is not anymore by most interpretations and statute. The only possible stretch on that, and it was a somewhat tortured analysis, I said since child support sometimes runs till the completion of high school, another 4 or 5 months after 18, that arguably an argument could conceivably be fashioned that the court retains jurisdiction over visitation for that period of time too. Although there is no statutory or case law support for that yet, I suspect if someone did bring such a case on an appellate level, such a result could be reached, I suppose. But what is it? I would at 8 now, unless you're just looking to focus on what she didn't do for the last 5 or 6 years and to historically punish her and make her life miserable for that. Assuming, let's assume that the court had some ability until he graduates high school, which I don't think I do, now that he's 18, to enforce this. Think of all the missing pieces here. For you to proceed with a contempt, aside from everything Ms. Wilson has mentioned, there's so many legal and procedural steps which are deficient or non-existent here. Let's assume they were all in order. I would still have to look at willfulness and intent. You would have to show that he's really eager to speak, that he actually wants to speak to you, and that she's impeding it. It wouldn't be good enough to say, he would have spoken to me a few years ago, but she's maliciously worked on it to the point where he can't anymore. We couldn't get into something that level of detailed analysis. It would have to be, assuming I had jurisdiction over him still, which I don't, that he wants to speak to you or is willing to, and that she is actively impeding that. How would that be established or presented? I can't just assume that, and you're asking me to assume that based on what you're saying the history of lack of cooperation is. So I'm not sure you get what I'm trying to drive at, but if you do...
Yes, Your Honor put several questions on the table, and I have a very detailed and consummate, response that I would like to give here. Yes, he is 18.
If it addresses those concerns of the court, I'd be delighted. Please.
I have like 5 things to address. If the court will allow me to speak,
Okay.
I will address
Please.
each one in turn.
Please, just put it.
As long as I have
just compartmentalize them when you move to a new one. Say now this is. Don't mishmash them. Please say number 1 is this. Then when you proceed to number 2 and
Yes.
3, number them. Okay. Thank you.
On the issue of whether the court has jurisdiction, it's my argument that as long as I'm required to pay child support, the court has jurisdiction until he graduates on May 24th of 2024. On the issue of do I just want to punish or seek some kind of remedy going forward, yes, I think should respond to sanction for the last 5 years, and going forward, the court has clearly the ability to order the minor child, whether it's Donna House or going to my father's house or bringing him simply to my house. The court clearly has the ability to make such an order.
Would you go to Donna's
Your Honor,
house?
also...
Would you go to Donna's house? Because 6 years ago you had that option. Would you go? If that, you said
Well, yes, I will, but...
an order that you'd invite, that you would view as a victory for you, would you cooperate with that order, considering that your whole theme all along has been, I shouldn't have to go? Would you cooperate with that?
Yes, I would, Your Honor, and let me clarify the issue on Donna's house. I don't believe that Donna's house sends the right message, but I will go to Donna's house, and what I find so particularly annoying is that Shannon Wilson is always saying, I could have went to Donna's house, like it's picking up a loaf of bread at the store. I believe that we would have met the same objection. If cannot bring the child to the telephone, how is she going to bring him to 601 North Pecos? I think that Shannon Wilson is awfully insincere when she says I had a right to go to Donna's house, because I'm sure they would have mounted the same objection that she doesn't want to go. Next issue, Your Honor posed a curious question. What should I do to make him want to call me? Well, I've tried everything.
If your position is it's curious in the sense of it being irrelevant, then you don't have to answer it. Only answer questions that you find legitimate and factually and legally relevant. You're an attorney. If you think it's curious and odd and you made the point that you think it is and you have that for the record, then you don't have to bother explaining. If you think it has arguable legitimacy, then you explain the answer. If you think it's nonsensical, you made that record, you don't have to then expound on something that you think is legally or factually irrelevant to the point of being nonsensical. So you can move on to what you think may be important then.
Well, I am addressing what's important, Your Honor.
Okay.
I guess I must have misspoke. I think the word is surprise. I guess I was surprised that Your Honor asked what I can do to make him want to call. Not having any contact with him, I don't think there's anything I could do to call.
I agree.
On the next issue,
by the
Your
way,
Honor,
I tend to think that's true, but I still have to pose it to you that what can you do at this point? Because if you can't do anything constructive in combination without being able to, if that's in combination with him refusing to visit with you or speak to you, and his mom not as established as being obstructive in that point, and him now being beyond the jurisdiction of the court, if I don't have the ability to hold her in contempt at this point, which not only is a problem with him being aging out as the obvious one, but if he was still within the jurisdiction of the court, again, I would have to find that your conduct all along, probably I would have to find it was beyond reproach. Plus, I would have to find that he was open to a relationship, but she was obstructing it. So now that he's 18, if we assume that there's little or nothing that the court can constructively do as to the here and now, how would you make him want to visit? Certainly not with this endless litigation, I don't think. Common sense-wise, that's just adding a whole incredible layer of stress.
So let me address
what do you
Your
think
Honor.
you could do? I think one answer is to let some time pass. But if you're not willing, if you can't prove, you would essentially at this point, if he's still within the jurisdiction of the court, for me to deal with the willfulness or intent of a contempt, plus for me to issue any constructive orders, if he were under the jurisdiction of the court. I would have to establish that he is open to this relationship, but she keeps getting in the way of it. And I don't know anything beyond what's been established in findings at earlier hearings and information. And you can't show anything.
Well,
You can't show anything you're willing to do. I don't think it's curious. I think it's a bullseye question at this point. If you're really concerned about this relationship and not constantly being right about this case or being addicted to the litigation, if you really, really are concerned about this relationship, then I reiterate what I mentioned 10,000 times at the earlier hearing. Then you would have complied with supervised visits 6 years ago, which after a visit or two, we hopefully would have gotten a positive report enabling us to lift the supervision and have you have a constructive, loving relationship with your son. Or you should have returned to court and succeeded on a rehearing to convince the court that supervision should not be appropriate. But now that we're at this point, let me make it more simple. Outside of the context of this case, let's just say this case and these legal proceedings didn't exist, but the set of facts existed. Let's not get distracted by the law, who did wrong, who did right, the contempt, all this. What if it really is about your relationship with your son? Let's assume you're right, and it's not about being right or being addicted to this whole procedure. Let's assume I'm all wrong about that, and it's purely about your son. And let's assume we didn't have this backdrop of this litigation. What do you think she should do or he should do at this point if it's true that the 18-year-old doesn't want to speak to you, right, wrong, or otherwise, and she doesn't seem to be able to do anything to compel him to? What do you think would be done, should be done? If you're not willing to wait till he's open to it, what do you think from a behavioral, real-life standpoint would make sense at this point?
Well, Your Honor has raised about 10 issues, and I would like to have an opportunity to respond.
One simple question. Assuming we didn't have this case, but we had the identical set of facts, 18-year-old won't talk to dad, and we can't establish that mom's undermining it, what do you think you should do if you're still committed to that relationship?
What would Your Honor have me do?
If you don't want to, if you want to answer a question with a question, I'm happy to answer it. Maybe a little, but you might see an incredible thought if you just dump all this, and B, you wait a few months. Maybe that could be productive. Send them a from the heart. Send them a from the heart email or text that doesn't criticize mom, says nothing about the case, no referrals to the case, to mom or anything else, and just saying, I know it's a long time, but I want to do what I can to reestablish a relationship. I'd love to hear from you sometime. So you asked, and I told you what I would do if I was in your situation. Not only do I think that's good advice, that's exactly what I would do, because I'm good at commiserating and putting myself in other people's shoes and giving a direct answer as to what I think I would do if I were in your situation. You may disagree totally, but you asked me what I thought, how I would handle it. That's how I'd probably handle it.
Well, let me respond.
Sure.
I've already done exactly what Your Honor has said. Okay. I've sent the heartfelt letters and emails. I've sent the correspondence. And contrary to Your Honor's representations, I've never referred to any litigations. I've never once mentioned the mother or criticized her because I know that's inappropriate.
Her and him are well aware of all this because they've lived it nonstop for 6 years. Let me put it that way.
How do you know that, Your Honor?
How do I know
She's
that?
not supposed to.
I'm not going to answer a nonsensical question. Look at this record. Look what they've lived this litigation for all these years. It becomes a centralized part of her life. How should I have to answer that? How do we know that this hasn't caused remarkable stress and how litigation has not been a focal point of your life, her life, and his life? I'm not answering that. You're a licensed attorney. That's nonsensical. I'm not answering. I'm happy to answer any sensible, constructive question like, what should you do now? How do I know that someone isn't eaten alive by having their life under the specter of constant soul-wrecking, financial-wrecking litigation? And how does it not spill down to a child when a person's of limited means? I've answered the question by reacting what I think about the question. Therein is my answer. Unless she's a
Can I
highly unusual.
respond,
So
please?
why don't we go? Okay, this
I want
back
to
and forth
respond, Your
dialogue
Honor.
where I keep trying to get through and I'm failing miserably in each hearing.
No.
Just go ahead and complete your statements for the record, since you have material
Let me
you
make
want
the record
in the
here,
record.
okay?
Let's go ahead.
This court must be aware that the parties are admonished, they've been admonished, and they're not allowed to talk about the litigation. If is bringing the minor child into litigation, that just shows she's violating another court order. The minor child should not know about this litigation. And Your Honor is wrongfully presuming the term you used, respectfully, was
You made a point that it's wrongful. I made a point it's beyond absurd. It is beyond absurd to think not only are they both aware, but that it's a central part of their life. And that could very well be the case whether she's been poisoning the well or not, just by the fact this exists. And we do have prior findings, although I wasn't the judge to make those findings, admittedly, that she was cooperative at that point. So again, I answered your questions, you answered mine. It's not going to. This type of dialogue isn't going to improve with this Q&A back and forth. I don't want it to disintegrate quite as badly as last time. So let's go ahead and you proceed with the statements and representations that you feel are critical for the record, and that would be great. So go ahead.
Yes. Well, Your Honor said the word financially wrecking litigation. Doesn't have to spend any money on lawyers.
Nice,
She
good
gets
point.
free lawyers all the time. She has all the time. She's still getting a free lawyer. She got a free lawyer in the Supreme Court of Nevada, the Supreme Court of the United States, in federal court litigation. So your characterization of financially wrecking litigation is
I don't think she had a
false.
free lawyer from the beginning, but fine, that's fine. I'm not.
Yes, she has,
I'm
Your
not
Honor.
qualifying what I said about life, dramatically life-affecting and emotionally devastating, and the fact that this doesn't stop. This won't stop until you get what you want, and even when you get the orders you want, it won't stop, because then you'll say they're not complied with. It'll be a vicious cycle. You want to endlessly litigate this. You don't want, do you?
That is-
If I could wave a magic wand and you had a good relationship with your son, or a relationship with your son that you need, he's open, let's say, and it's going to take some progress for you to get where you need to be with him. It's going to take some hard work, but he's at least open to it. But you would have to stop all of this. Would you continue with this, or would you say, let me go to work on this relationship with my son, and I'll put in the hard work regardless of what historical culpability is assigned to who? I'm willing to do that. If tomorrow he was saying, Dad, I'm open to this, but let's take it slow, would you jump at that opportunity if it meant forget all this litigation, or what would your decision be?
May I speak, Your Honor?
Yes, but let's have intellectual honesty for the record. You're an attorney. If you don't wish to answer the question, you don't have to answer it, but don't act like you're answering it by branching into another topic. Would you like to answer that directly? If not, I respect that and accept it, and just please proceed on with your record.
I would like to answer, and respectfully, Your Honor, without interruption.
Are you going
I
to
have
answer,
only
do you wish
one-
to answer that question or hijack the narrative?
I'm trying.
Thank you. Proceed.
I'm
please.
trying, Your
Thank
Honor.
you. Thank you.
I have only one goal, and that's to be reunited with my son. I have fought as hard as I know how to get with my son. My only recourse is to go to court, and I would abandon the litigation. I would move heaven and earth to see my son. That is my only goal. It's only ever been my goal, is to see my son. And that is the most intellectually and emotionally honest thing that I could ever possibly say. All I have ever wanted is to see my son. But frankly, if I could just go off just a little bit here, I believe that has lied to the minor child about blowing up schools and shooting up schools, and I believe that's why he won't talk to me, because he must believe that the Shannon Wilson school shooting hoax, that was somehow legit. But in response to your question, I have only one goal, and that's to somehow be reunited with my son. And frankly, if I can carry on being straightforward and completely honest, if I'm denied again here, by your honor, I think my only recourse is to continue litigating. I can't see how waiting more time would profit anything. I've given up 5 years, 3 months, and 18 days of my relationship has been sacrificed. And to me, that's totally unacceptable. Now, I also wanted to address what Your Honor had mentioned about Ochoa's prior rulings. Well, let me just say, I believe Ochoa was biased, but that's not only my opinion. The Honorable Chief Justice Jerry Weiss reached that same conclusion, that Ochoa was actually biased when he disqualified Ochoa. And frankly, all of these orders that were issued by Ochoa should be stricken because he was biased at the time he issued these orders. The other thing I'd like to say for the narrative in response to Your Honor's inquiries is that has known for some time that, apparently, according to her anyway, didn't want to speak to me. But when was she going to come to court? We have a problem. And also, I've never heard anything from. This is what I would expect to hear, that, hey, call your father, or I'm going to suspend your allowance, or no more video games, or no more Xbox. She hasn't tried anything to compel him in any meaningful fashion. So I think that's important to know also. The point is, again, I don't mean to be too laborious in stating this again, but the litigation that has been ongoing has only ever had one focus: to speak to the minor child and reunite with him. I've done everything in my power that I can legally do through litigation to try to speak with him, but I'm thwarted at every turn, and I would respectfully defer to Your Honor's good judgment and throw myself upon the mercy of this court and beg you. If I were present in court today, I would be on bended knee saying, Judge Henderson, please tell me what I can do to speak to my son in person. Whatever Your Honor recommends or orders, I will faithfully follow, because as I've stated time and again, I have but one goal: to see my only son. That's all I want to do. And if there's something that Your Honor can fashion here, I would be eternally grateful. And so, again, without getting too maudlin or too emotional or too overboard, again, all I've ever wanted is to speak with my child. And I beg you, Judge Henderson, please tell me what to do, and I will faithfully follow Your Honor's directive.
Okay, Ms. Wilson?
I think there's only 2 points I want to make in follow-up, and that is Judge Weiss did not find that Judge Ochoa had actual bias. That order will speak for itself. And the other thing is
so sorry,
regarding
I was looking for it. What's the, do we know the date of Judge Weiss's disqualification?
If you will bear with me, I will find it for you, Your Honor.
Okay, sure. Just proceed on with your observations and remarks so that we can find it later. Okay.
Well, I'm not so talented that I can do 2 things at one time.
Don't
I
bother
will.
looking. In other words, don't bother looking for it anymore. You can proceed with your remarks.
All right. I will tell you that I believe it was filed in 2021. No, I
September
apologize.
1st.
2022. It was filed in 2022.
1822 order. Oh, it's for Judge Harder, where he apparently.
Go back earlier.
Oh, it's earlier than that. So
It would have preceded Harder's order.
there was a motion to disqualify Harder. Okay, so it was before that.
Go back earlier.
Yeah.
September
It
of
was around
2021.
September of 2022, Your Honor.
9/30/22, order a respondent's motion to disqualify Ochoa. So it's 9/30/22, and it says, aside from all the preamble and such, let me see what the rationale for the ruling is. It's pretty.
You were adversarial,
Quotes on-
according to.
It has extensive discussion, extensive statutory recitations, so I'm probably doing a disservice to anyone if I try and condense it like I intended to. But let me see if it gets to the, it looks like, and this could be an unfair or inaccurate summary, but it looks like they're saying although the judge has done nothing wrong, that applying an objective person standard, that since he's independently suing Judge Ochoa, that from an objective person standard, they would assume it's difficult to accept that the judge would necessarily be fair and impartial if he or she is being independently sued by the litigant. That's what it looks like. Maybe that's an inaccurate summation of a 6-page order, but it basically looks like the judge didn't do anything that we can find to be bias or any sort of conflict or unethical behavior. But after the inquiry fails as to, number one, whether a judge has indicated bias or committed an unethical act, etc., then we can drop down, number two, to the other standard of, however, would it appear on the reasonable person standard that the judge might be tainted by bias. And for that inquiry, we can also look at not just conduct by the judge, but has the party put the judge in a position where the objective person might conclude the judge might experience difficulty being impartial or fair. So so Judge Weiss, number one, indicated Judge Ochoa has no wrongful conduct, but number two, since Mr. Phillips is now suing Judge Ochoa, applying the reasonable person standard, the impartiality of such a jurist could be questioned in that scenario, and that's what it looks like to me. Now, if that's an unreasonable or inaccurate summation, one or both of you can correct that on the record. Okay.
I would just like to add that the buzzword is adversarial.
Okay.
Jerry Weiss noted that I'm adversarial with Ochoa and vice versa.
But that doesn't mean he's adversarial. It means he's now an adverse party to the lawsuit. But you can jot down what you want to say in response, and Ms. Wilson will continue with her record, and we'll go from there. Okay, Ms. Wilson, please proceed.
Thank you. The other point simply had to do with the court's continuing jurisdiction. Mr. Phillips had made a point a little while ago that if he still is obligated to pay child support, that the court would still have jurisdiction over for custodial and visitation purposes as well. That was laid out plainly in my opposition and in my request for submission of a proposed order filed on November 19, 2023, referring the court to that document and the conclusions of law. There are several things that lead to the opposite conclusion that Mr. Phillips has supposed. That is the Child Custody Jurisdiction Act. Statute 125A.035 defines child as a person who has not attained the age of 18, which has. Additionally, 125C.001 states in relevant part, it's the public policy of the state to ensure that minor, emphasis on the word minor there, children have frequent associations and continuing relationship with both parents after the relationship is ended. Not a minor, therefore the court's jurisdiction over or for purposes of child custody is terminated. 125C.0605 defines adult as a person who is at least 18 years of age or an emancipated minor. NRS 129.010 states all persons of the age of 18 who are under no legal disability and all persons who have been declared emancipated pursuant to 125.129.080 to 140 inclusive are capable of entering a contract and for all intents and purposes held to considered lawful age. It may safely be inferred from that statute that he can do as he pleases now, and the court has no jurisdiction to compel him personally or through his mother to have visitation or contact with his father. By contrast, Nevada's child support statute, which has a more expansive definition of minor child and includes a person who is under the age of 18 if still enrolled in high school, is by its very terms limited in its application to Chapter 125B, the child support statute. Therefore, the court has no jurisdiction over custody or visitation. Thank you.
Thank you very much, Mr. Phillips.
Well, I would like to go back in history just a little bit here, back to November of 2018. Then Judge Henry, she's no longer a district court judge, but the parties myself and had been separated for a couple months, and there was a TPO in effect, and yet Judge Henry wrote on November 5th of 2018, quote, Phillips is currently having contact with by telephone and text messaging. Why is this significant? Well, that a couple months after they had left, meaning the minor child had left the residence, I was still talking and we were still communicating. My point is, something happened when I was outside of his presence. Something happened that suddenly made him switch on and not want to talk to me. I received from on, I believe it was October 1st or 2nd of 2018, a text that says, Daddy, I don't think I want to talk to you anymore. And at the time I received that text, I couldn't figure out why he didn't want to talk to me. But it was several months later, in open court, I learned about this supposed school shooting hoax, where Shannon Wilson urged the court that I had threatened to shoot up the minor child's school. And so I believe what's happened.
Your Honor, we've been over this in the record half a dozen times, and Mr. Phillips's inability to understand the facts related to a document that he himself produced from Metro that is the source of this quote-unquote shooting has nothing to do with me, and it has everything to do with him introducing this document into evidence in the TPO hearing. This has been litigated ad nauseum in front of Judge Ochoa, in front of the Supreme Court of Nevada, and at other times too. And I would beg Mr. Phillips to stop misrepresenting the record that he himself created that had nothing to do with me. Thank you.
Understood.
Well, Your Honor, at this time, just simply ask Ms. Wilson if it's true that I threatened to shoot up the school. She won't give an answer to that.
I have no idea what you threatened, Mr. Phillips. None whatsoever.
That you were the purveyor of advancing this document and not her. She's not saying that you had the mental intent to dismember and kill people.
Shannon Wilson, on October 18th, Shannon Wilson said that Mr. Phillips threatened the minor child's school. Now,
I didn't.
This is doing...
Never
Yes,
said that.
Okay.
You keep saying that I said that, but you cannot point to any record in which I said that.
Get back to your relationship with your son, and let's try and get back to
Your Honor,
yes.
I just watched the tape yesterday. Shannon Wilson says that Mr. Phillips threatened the school. I will present that tape, and I will present a faithful transcription so you'll know that Ms. Wilson is lying to the court right now. She said that I threatened the school. Somebody called 911, I still don't know who, and they said that I threatened to shoot up the minor child's school. There was a police incident report, but law enforcement never contacted me because they realized it was a hoax. Shannon Wilson knew it was a hoax, and yet 3 weeks after the incident, she is in court saying that Mr. Phillips threatened the school. And I'm going to bring that to the court so Your Honor will know that I am telling the
versus
truth.
threatening to shoot up the school are two very different things.
The court does have some knowledge of the historical entry of this matter into the record, and her commentary dealt with a document that you procured and brought to the attention of the court. And you've made these representations before about what she represented to the court, and the court does not believe, the court's not just simply not merely not believe, but is convinced that she made no representation with that import or intent. If you feel otherwise, you can supplement the record with whatever filings or transcripts you believe are necessary. But the court's
I will
convinced-
supplement
The court's
that.
convinced that any dialogue on
But,
that.
Judge, why would you make that invitation?
Thank you. Any dialogue by her on that, as to that issue, was mainly for the purpose of just indicating further issues that she believes you're creating. It wasn't meant to indicate that you're a culprit or a suspect, or that she believes you're going to shoot up a school. That seems to be a real reach, a real tortured analysis. If you feel otherwise, it doesn't do you any good to aggravate her on the record with this. Just move on to your next issue. And if you want to supplement the record with some transcript or whatever, you are at liberty to do so. Let's proceed.
I will absolutely do that, Your Honor. I will supplement that.
Thank you, Your Honor, for ensuring that this interminable proceeding continues. This is absurd, and I object to the court's invitation to Mr. Phillips.
Okay, Ms. Wilson, Ms. Wilson, you know better than to indicate that the court should speculate in advance about what documents are being advanced, and assuming that no one will have a right to file them. People, pro pers, as well as people represented by attorney, file whole multitude of documents, some of them relevant, some of them irrelevant and random, and you should be, I thought you'd be extremely pleased and confident. It's not going to extend these proceedings any further, as you think. It's just going to establish the truth of what you're saying, so you should never be indignant about someone, despite their intent being the opposite, to establishing for the record that what they're saying against you is frankly ludicrous. The last thing the court wants is for these proceedings to be continuing, and I think it's an insult to the court when the court's done everything humanly possible to bring some sense of possible finality or even just rationality to these proceedings, and they continue to be headed in the wrong direction, and the court's efforts are focused on bringing these things to some final natural end, which is the whole point of the court's commentary. And if you can find a judge in this jurisdiction who would have handled it differently, to indicate here's what the true record shows and it supports what Ms. Wilson's saying, but a judge who would say, and you're precluded from filing or pursuing anything that might contradict that if you have it in the record, you're not going to find someone who would say that. You're not going to find a judge who's going to say, if I'm wrong, you're precluded from filing anything to point on the record for appellate review or review on this level that the court was wrong. I'm not going to make that kind of order. So, by what you said, you at least established one thing that he's right about. So he has the right to file that if it's that important. If you didn't know to interpret that as just let's move on type argument, I don't know what to tell you. You know that's what it was meant. So let's move on. Let him get through his statement, please, and then please.
Well, may I, Your Honor? Because I would like
whatever commentary you two have. Bring it to the court's attention after the other one speaks. But if we continually get sidetracked with arguments between the court and one or now both counsel or between the parties themselves, you would strongly agree, I'm sure, that that's counterproductive. So just he'll proceed on, well, now I'm even lost as to who was, which one of you even had the floor? I think it was Miss Wilson still. Miss Wilson, right? Am I right? No?
Yes, Your Honor.
Yes, thank you. I'm sorry. Ms. Wilson.
The point I would like to make, Your Honor.
Please proceed with the remarks that you jotted down that you felt in response need to be made. I don't think it's productive for us to get sidetracked anymore.
And that is my very point, Your Honor.
Understood.
It is not productive to get sidetracked and to invite Mr. Phillips to file things that have no relevance to the current proceedings. Every invitation that you make to Mr. Phillips, he will take you up on.
If after the court's detailed explanation, you still interpret it as some malicious intent to encourage someone who's addicted to litigation and who the court is certain has caused great harm to your client by this, inadvertently or otherwise, I don't know what to tell you. If you think it's proper for me to say, don't file anything no matter what it is in the future, I'm not inclined, as you'll hear later, to entertain any further motions on this matter. I can't tell him what he can or can't file, or that he can't pursue any appellate remedies, and I don't have that ability, and you know that. I have the ability to indicate I'm ending this today, and further motions before they're set for a hearing will be subject to heightened scrutiny, and in this case, pretty conclusive scrutiny. If the court concludes there's no further jurisdiction, I'm not going to be able to entertain any further motions or activity on this case. So he can take that and pursue it with it however he wants. So let's get back on track, because I think you had some important legal procedural points that you were making, which was certainly on target, and let's work through that, and let's get off this issue. I'm very confident, if you want to go down this road, that no one reviewing this record, the entirety of this record, would think that remark by the court was motivated to disrupt people's lives any further or to actively encourage him. It was sort of almost a dismissive, let's move on type remark. I said, I made it clear, Miss Wilson absolutely did not do what you said. That's clear. And if you believe otherwise, instead of all this endless argument on the record now, just like any other point in this or any other proceeding, someone always has the right to, doesn't mean they'll have the right to force the other side of their attorney to spend time and money responding, because I don't intend to entertain further motions on this matter if I see motions which the court has no jurisdiction on, which will be probably any conceivable motion. So, so let's move on, please.
Thank you for that clarification, Your Honor. Much appreciated.
Thank you.
That is, the points that I had to make were regarding Judge Weiss's order and regarding the court's lack of jurisdiction at this point over any visitation or custody orders. That was all I had, Your Honor.
Excellent. Mr. Phillips.
Well, I have to say, I don't want to alienate myself from Your Honor, because I have to say that I've litigated extensively in the 8th District, and I believe that you are a good and honorable man, as is Jerry Weiss, and also Judge Williams, I believe, are good judges. I really do believe that. But at the same time, I am really off-put by Your Honor has twice now said that I am addicted to litigation.
Well,
I think that is enormous.
You understand, don't parse things out of context. I said, are you addicted to this litigation, or if you actually had a shot at a relationship with your son, would you let this all recede? And you said if you had
yes, I would. I would enter.
You would stop it all. That was the context of that.
I would gleefully enter into a stipulation to halt the litigation against Shannon Wilson, and against the Legal Aid Center of Southern Nevada, and against Hutchison Steffen, if only this court could fashion an order allowing me to see my son. I would do anything. I would give up the addiction, as Your Honor would put it, if only...
That might have been, if it was practical to it might have been a wonderful result 2 years ago. I could have demanded that they send him for a clinical interview to explore his willingness and interest, and the court would have been able to proceed from there, and then we could have been done with all this. But now he's beyond 18, and I'm not sure what you expect from the court at this point.
I believe that as a family court judge, Your Honor can exercise discretion. You know, I've been oftentimes critical of what I see as an overreach in terms of exercising discretion. But it's my earnest belief, if the court were to order the parties to go to Donna's house or to meet at my father's house, Your Honor could do that, like, real easily, and I don't think that have any kind of argument to the contrary. This court could, if it wants, I believe Your Honor could do it. If you want, you could order the parties somehow to come together. Because the truth of the matter is, if I can't see my son, I'm going to keep trying. I want to be proactive. I'm setting a good example for my son of fighting for what's right and having a good, clean fight like I've done for the last 5 years. All I want to do is see my son. And I'm dismayed that Your Honor tends to believe that you're powerless to do anything. I think that Your Honor could very easily issue...
I'm very sorry, but you hit the nail on the head. I think you phrased it exactly correctly. I do believe at this point I am powerless to address it. I do believe that. I do.
Well,
I would have been probably more than delighted to weigh in with suggestions and entertain this a couple years back when there were options at my disposal, not the least of which would have been a clinical interview to explore this issue. I do believe you hit the nail on the head. I am powerless. That's all.
Well, let me say that
that was against the technical backdrop of what Ms. Wilson was indicating, that just because that even though there conceivably could be an analysis that if majority extends a few months beyond 18 for support purposes for graduation, could that be analogized to extending the jurisdiction to graduation date for enforcement of her visitation? I thought it was an interesting theoretical question, but the information that the court was aware of statutorily is similar to what she located, and no one's located anything which would be an exception, indicating that there's a sort of a different statutory animal and philosophy behind support. So the fact support can run to high school does not analogize to extending jurisdiction over visitation disputes till graduation of high school. And nor are there any cases that I'm aware of which have indicated that. And I dare say if there ever was a case that indicated that that's possible, it would look at equitable factors, and they'd say, well, if he's arguing that if support can be enforced up to graduation, that visitation should be enforced, then equitably he better really be a shining star on paying support, and you're not paying any. So I think there's all sorts of moving parts here. Yes, I do believe I'm powerless. I wish I could have had this. I don't know exactly what kind of dialogue was occurring. I know what the record is. I haven't reviewed transcripts per se, except on that issue, because I knew it was going to come up about that school shooting, but I haven't really done a deep dive on a transcript with Harder and Ochoa as to whether they thought an interview might shine some light. I don't know what they thought on that, but it's something that would be in my toolbox if he was 15 or 16, but he's not. So, just don't.
Well, you know, I have been paying child support. I don't know why Your Honor is representing that I haven't.
Okay, let's clear that up then. What is your support order, and are you timely on it? If you're timely on your support, I'm not only going to correct the record, I'm going to directly apologize to you on the record. What is your monthly support order?
It's supposed to be $1,750, but I'm going to be making another motion. I made one earlier, but it got lost in the shuffle of all the disqualifications.
When was the last payment made?
I believe it was every month I've been making payments, every single month. At least
This month?
I make as much as I can.
How much have you generally been paying?
About $500 a month, sometimes less.
The months you paid less are the months you didn't pay any?
There were not any months that I haven't paid any in the last probably 2 years. During COVID, there were some months that I didn't pay, but I have since been making the
time we were dancing through all this, you couldn't have brought some, of all the motions, 48,000 motions to annihilate her, you couldn't have included one motion to review and adjust support, or did you?
What do you mean to annihilate her? I don't understand what Your Honor means.
Because that's exactly how I feel, because I asked you the questions directly, and you answered directly that you're still committed to punish her. But you did qualify that if you could preserve this relationship, that you would shift focus. And I do think that my characterization is not hyperbolic or a gross exaggeration. I stand by it. But that said, have you attempted to lower it through this process?
Yes, I have, but the hearing didn't go forward for a variety of reasons.
With the understanding that maybe I'm wrong, but I believe that they have a significantly different representation as to the history of support compliance, but we'll wait on that. Proceed with your statements. But I want to avoid all this argument and cross-argument between the three of us because, as you've seen, it's wearing thin on my patience. The good news maybe not quite as to the extent it did last time, but let's avoid it from getting to that point because that serves no one. So let's proceed. Without
belaboring the point, but to make my record, let me just say it one time.
Okay.
Nothing I file is to punish Corpac, and nothing I file is to destroy her. Everything is with the intent only to see my son or for the collateral matters, whatever those are, but nothing is directed.
We don't know, aside from a Cho or one of the judges saying, making a finding that she's cooperating, if I don't have a really reliable or even intimate view as to what effort she's making or not making, how would it be not punishing her to proceed with this parade of contempts against her for every visitation you missed if I have no knowledge of what role she played in it at any time? Maybe.
Well, why don't we?
Should she still face contempts in your mind if she is encouraging him? Let's say for the last couple of years at least, or you can speak to your dad if you want. That's great, and she removed herself from it. If he independently simply doesn't want the contact right now, and he's decided on that, should she be the victim of these of extensive contempt proceedings?
A victim? I don't know anybody's a victim of contempt.
I guess what upsets me more, and which I find more troublesome from a behavioral or even moral standpoint, is that when you say, no, the focus is not on this litigation, it's about seeing my son, but every remedy of how we accomplish that, even when I kind of telegraphed a sensible, humane answer to you, which would be, if he was still within the jurisdiction of the court, let's get the boy and see what he has to say, see how he feels about it. You seem to nullify that and say we should just jump to the conclusion that she's poisoned the well and that she should be hammered for this extensively. Why is it not important?
I've never used the word hammered.
Why is it either not important what role she played in this, or if it is important, why should we just assume that she always behaved in a malicious, diabolical manner?
Well, I think the court can probably presume from the facts that the minor child has, what they're really saying is the minor child has lost interest in his grandfather and his uncles. Like it says in the affidavits, the minor child was with the grandfather every Christmas, all the birthdays. You know, here's my point. Has gerrymandered this so that she is the only blood relative with whom the minor child ever has contact. He has extensive family in Las Vegas, cousins, uncles, the grandfather, and I guess according to Shannon Wilson, that the minor child has lost interest in the entire family. That just doesn't make any sense. If it were only me, maybe they could get away with saying that, the child doesn't want to talk to the father because of something the father has done. But how do they explain the fact that the child suddenly doesn't want to talk to his namesake? My father is named Phillips, and so is my son. They were like peas in a pod, and then saying, bonds with the minor child, and he never has any contact with anybody bearing the surname Phillips. That is a provocative fact that the court has to entertain. Now, I'm not saying hammered, like Your Honor said, or punished, or devastated, these other adjectives. Perhaps she should pay a sum of money to the court. I'm not urging incarceration. I'm not urging anything that's outlandish. I'm saying that she should be held responsible. Or in the alternative, if the court can think of something. Now, I know Your Honor respectfully cannot give legal advice, but if Your Honor were to render an advisory opinion, I would faithfully follow it because, again, my only goal is to see my son. And I would stipulate for the record that I will suspend all litigation if only I could spend a day with my son. And my word is my bond. I have never misrepresented to this court. They have never alleged that I'm misrepresenting. So if Your Honor could please come up with an advisory opinion of what to do, I'll do it.
Very good. Did you have anything further? We'll take a quick 5-minute break. We'll be back for any concluding remarks of the parties, and then court will proceed to its decision. Thank you very much.
We're on the record, Your Honor.
Okay, very good. We're back on the record. Okay. Mr. Phillips, do you have any additional remarks?
Well, I guess it depends on whatever Your Honor intends to add in the next few minutes, but I want the court to know again.
It's not a game. We don't say, well, I'll wait for the ruling and then argue against it. I mean, since I've already, which I'm unable to do in most cases, I already told you, telegraphed it, that I don't have jurisdiction. I may have a suggestion or two. I can't require the other side to comply with it. I may have a suggestion or two.
Again,
you're probably not going to be interested, and neither will they, but I'll throw it in there for what it's worth.
I just wanted to renew my offer, if you will. I know it's kind of an offer out in open court here, but I would suspend all litigation against Hutchison Steffen and the Southern Nevada Legal Aid Center if only I could see my son for one day. And, I think that's something the other side should consider. If they're worried about being hammered and devastated with litigation, all they got to do is let me see my son. And I just don't believe for a moment that he doesn't want to see me.
Why don't you, what would lead you to believe that after everything that's happened the last 6 years and his mind being consumed by this litigation, what makes you think he wants to? Do you have knowledge that he wants to?
I don't have any knowledge. I don't even know what he looks like. I have no knowledge of anything because they don't inform me.
You have his cell number. If he wants to see you and you've been texting him and you have no response, that might mean he's not ready.
Or it might mean that phone in a drawer and the minor child has a new phone.
Yeah,
I know for a fact
How would we know?
that, because, Your Honor, let me finish, please.
Okay.
I know this is not something that can be proved, but I know for a fact that has lied to this court saying that I'm threatening to kill her and that I've, beat her up every day for 20 years. I want this court to understand, yeah, there was a domestic violence restraining order, but there was no supporting evidence, no 911 calls, no pictures of bruises, and despite all the supposed beatings I gave years, she never once thought to get the teddy bear with the secret camera in the bow tie to film it. My point is, there are only allegations out of mouth. There's never been demonstrable, tangible evidence that you could put in front of a jury. And if I would have had a jury on that DVRO, I would have prevailed certainly. The point is, I believe that has been poisoning the minor child because she fears that if there's any communication with the son is going to discover that his mother has been lying to him about this stuff, lying about me, the father. That's what's going on because nothing explains the fact that he doesn't want to see me. As Judge Henry noted in November of 2018, during the restraining order hearings, she said that Phillips and the minor child are still, talking to one another. It was literally about 2 days after the school shooting incident when the child stopped speaking to me. So I believe that the whole school shooting hoax thing, now you heard Shannon Wilson say she doesn't know if I threatened to shoot up the school or not. Shannon Wilson has seen the event report. The event report from Las Vegas Metro is clear and unequivocal in all capital letters. No threats were made. And yet Shannon Wilson is essentially playing dumb, saying, I don't know what Phillips did. Law enforcement never contacted me. The exact words of the sergeant who conducted the investigation, which lasted like 20 minutes, the judge said it was BS, B-U-L-L-S-H, the whole word. That's how the judge described it. And yet you have Shannon Wilson, who finds domestic violence under every law.
I'm not going to, I'm not
Still
going to be getting into any school shooting material, so you know what we're going to be talking about,
Well,
so let's move on.
Well, thank you very much, Your Honor.
Okay. Now, Ms. Wilson, there is something that, and he can respond to it before I proceed with my rulings. What troubles the court on this case, and it's kept it up at night both the last couple times, is there's so much more going on here than just litigation between two parties. The system in general doesn't do much to protect or compensate people from repeat or harassing or very expensive litigation. It's critical that people have access to the court and that's not foreclosed. But at what point do we protect people, agencies, and businesses from repeat, maddening, harassing litigation that there's no basis for, brought by someone who's eventually probably going to be judgment-proof when there's countersuits for attorney fees, etc. And against this backdrop, this case is concerning on many levels, and not the least of which are the following three. Number one, the devastation emotionally, psychologically, time-wise, and yes, even financial-wise to your client, because she didn't always have pro bono attorneys, I don't believe. And even if she did, only a fool would think that making your full, you have to, it's essentially having a second job to always be defending situations like this. It has a direct financial impact. People can't generate additional money. They can't even keep focused on their jobs half the time. So the effect it has on her, and the son is devastating, and the pity of that is maybe he would have wanted eventually to visit his dad. I've reviewed this every single year since 2016, non-stop litigation. It's not even like a 6-month reprieve that I found in there. So number one, the devastation to her. Two, what's occurring to legal aid, and the tens of thousands agency, the tens of thousands, or more to the point, hundreds of thousands that have been expended on attorney fees on this case, supporting her, and she absolutely needs it to defend herself from all this. I can't help thinking of the dozens and dozens of people, if not scores of people, a lot of them struggling single moms, etc., single parents that could have been, and single dads as well, that could have been provided services, and in other areas as well of law. Could be eviction matters, a million things. Helps for assistance for seniors, you name it, a gazillion things. That, where these services could have been provided if tens of thousands or not hundreds of thousands of otherwise billable hours were not tied up with this. I cringe to think what I keep thinking of the enormous number of additional people legal aid could have serviced. And then three, same thing with any litigation against Hutchison Steffen, the number of non-billable hours, not just that are not getting billed because can't get billed because you're graciously continuing to defend her on this matter, but then it takes a law firm away. Not only can the law firm not recoup any of that effectively from the opposing side, but then it diverts that law firm. Also, the damage isn't just hundreds of thousands they couldn't bill, but it diverts them time-wise from other productive cases that you could have been generating and the firm income and billing on. So it's just so offensive to the court that someone's right to the system to file cases does not, that there isn't sufficient or some remedy of protection where a person has that right, but when it morphs, perverts into something else that's causing so much destruction that there's often very little that can be done. And even if someone's declared a vexatious litigant where they cannot file no further motions without court clearance, what difference does that make in a case where, okay, you're not going to hear my case, I'm going to file all these appeals and a million other lawsuits and things. And he's made that, and I don't want to be accused of giving any ideas, because I'm just stating for the record what he's made abundantly clear 85 times on the record, plus hundreds of times by his actions. And I'm wondering, and I'm working backwards here in terms of remedies or protection, and then I'll get into why I don't think I have jurisdiction anymore. And I'm struggling with this, and if you can weigh in on this, because it's really frustrating. There's a few things that could be done. The court could find some basis to not only rule there's no jurisdiction, but to recuse on further, to recuse itself if it could find some basis, which is highly debatable. Now, if the court did
May I be...
once the court lays out the menu of choices or items it's reacting to, then you could, but I'm not going to let you react to something where you don't know where I'm going. Because number one would be if the court recused from the case. But then it becomes some other judge's problem, and you have to deal with repeat filings on that. And now, if the court, number two, doesn't recuse, but simply does not entertain further motions based on A, lacking jurisdiction, and B, then for good measure vexation litigant status, which wouldn't even be necessary because the court lacks jurisdiction, that just means it's gonna propagate an expensive appellate process like it already has. And third, if the court keeps on the case and keeps entertaining motions that it has no jurisdiction on, we'll just be caught in this continued vicious, expensive cycle. So I guess what I'm saying, I don't have a way of shutting this down beyond the vexatious litigant status and lack of jurisdiction, which usually does the trick. But there are those cases, and this is proven to be one of them, where unless he gets what he wants, which he made clear, he's going to continue to litigate. So if he can't force this court or another judge, if they determine that he's either a vexatious litigant or they have no ability to continue with it, that doesn't protect someone from, well, now he files appeals and separate lawsuits and all of this. So I'm at a loss, and it doesn't often happen, because usually once the court indicates it has no jurisdiction and/or someone's declared a vexatious litigant, that usually really slows down the problem and it dies on the vine after a number of months. But there's 14 gazillion things going on here. He's indicated a commitment repeatedly to continue that on unless he gets his way, which the court has no ability to give him his way, even if the facts suggest it. So when I'm done with this, I'd be more than, I'll hear from both parties, and I'd be more than open, I'd be more than delighted to hear some suggestion that's a lot more constructive than the ones I've come up with, because whether the court recuses, doesn't recuse, whether the court indicates it's not recusing, but I don't have the ability to do anything but vacate future motions due to lack of jurisdiction and supplemented by vexatious litigant status. Only a fool would think we're still not going to get bombarded with this nonstop, because I don't have the ability to issue edicts to other agencies or courts, obviously. When you see a lawsuit from this individual, dismiss it. So I think you understand what I'm greatly struggling with. The impact this has not only on your client, but you, your law firm, the Legal Aid Center, and it's just devastating. So I can't just look at this case in terms of the facts and limits of this case, which we do 99.9% of this time. A lot of the time, even if we resolve, some of the time, most of the time that's sufficient. Once in a while you get one case like in 1,000 or maybe even fewer, kind of like this, where no matter what you do, someone is going to, the innocent party is going to continue to get victimized with 28,000 legal proceedings in other agencies that I have no control in curtailing. So you must have a better idea than me about how to protect your client from that after I make these rulings, because this is not really the issue. The issue of me resolving it today, he's not going to stop. And he's saying he would if I make some suggestions that he feels he could implement, that it would all just go away. If we want to take a Hail Mary pass on that, we can do that in a minute. But first I'm going to go through these rulings, and then Ms. Wilson, if you have a suggestion of how we protect your client to any extent from this, because it isn't all just limited to this court, and in some cases, there are those extremely rare cases where we shut it down in this court, there's no jurisdiction anymore, or vexatious litigant status, but we continue with motions to disqualify or appeals that get dismissed early on. But here we have the tentacles flowing in so many different directions, where he seems to have devoted his life and has all of these other legal proceedings that probably against entities and court systems, and it would probably boggle my mind to know just how extensive it really is. Now, a few things. He indicated when I posed the question, is this about being right and addicted to the litigation, or do you really have good faith that if you had the ability to restore your relationship with your son, or at least start on that path, that you would take some action, that you would stop the rest of this and just concentrate on that? And he said, if I could do that, I would stop everything. Let's assume for the sake of argument, he's telling it like it is. It doesn't matter, because his definition of what would be acceptable would be if his son's is turned over to him, is delighted to visit dad, and everything is normalized. But instead, this would require some work on his part. If I had the case a couple of years ago and someone was putting this before me, I can and would have ordered some form of forensic interview, even just a therapeutic interview, or not even, maybe just an interview of some sort. How clinical we wanted to make it, I don't know, but at this point, it doesn't matter anymore. But I would have seen, let's get some form of objective insight about how the boy feels while the court still has the ability to do anything. So I do think that even though the court had offered that it's conceivable, and I haven't seen anyone take this case yet, on an appellate level, at least not in my state, and I haven't located anywhere else either. Doesn't mean it doesn't exist. But whereby it's been analogized, if there's jurisdiction over support, let's say he turned 18 in November, all the way to May when he graduates, that additional 6 or 7 months, wouldn't the court have jurisdiction to enforce visitation as well by analogizing those two theories? And I think it's clear the answer is no from what the court located after the last hearing, which is awfully consistent with was quoted by Ms. Wilson, namely statutory scheme supported by some case authority that really makes a distinction. We're not looking at contemporaneous identical rights necessarily in terms of the chronological finality of them and the reasons for that. And if there ever were, and I dare say if there ever was the basis for a finding to break new ground and to say, well, I'm going to run it all the way to graduation because that's how long support runs, that would probably have to be accompanied by a finding that someone has been very faithfully paying full support. But if it's more of a highly checkered partial support payments based on an assertion that I can't pay, when such a motion was never brought, when there were 42,000 motions brought on contempt in the interim, I dare say we wouldn't be able to get to where we need to be. So I think the court, in fact, has not only sort of provided that has gone above and beyond on this case for the respondent, for Mr. Phillips, providing a theory that turns out not to really have any validity and appeared to be a stretch from the beginning, but could have had some conceivable viability. But now, after the court's made inquiry and the supplemental material by Ms. Wilson, it's clear it's a non-starter. And so the jurisdiction runs out when he hit his 18th birthday, no doubt about it. And I believe that if this really were, as Mr. Phillips indicates, it's all about my son, it's not about the litigation, I'm not addicted to it, I'm not preoccupied with punishing her, while at the same time providing a series of statements that seem to support the philosophy behind all his motions, that's precisely what he's trying to do.